Welcome back and brace yourself. What you're about to hear isn't courtroom drama, it isn't legal fiction, it's real, raw. Unfolding right now in a federal courthouse where the unthinkable just happened. Defense attorneys, yes, the ones hired to protect their client, were physically removed from the courtroom by U.S. Marshals and walked straight into holding cells, not as defendants, not as suspects, as lawyers, representing someone else. And now they're behind bars. This didn't happen because of a single outburst, not because of one ill-timed objection. No, this was a slow, deliberate unraveling, a calculated campaign of defiance that pushed a federal judge past her breaking point. And when she snapped, she didn't whisper, she didn't hesitate. She ordered cuffs right there, in front of the jury, in front of the gallery, in front of history. Let me be clear, this isn't a metaphor. This is metal on metal. The sound of handcuffs clicking shut on licensed attorneys seated at their own defense table, the sight of U.S. Marshals flanking them like common criminals, the stunned silence that followed, not just in the courtroom, but across every federal courthouse in America. Because when a judge detains defense counsel mid-trial, you don't need a law degree to know something catastrophic just happened. And it did. Judge Sarah Caldwell, a George W. Bush appointee known for iron discipline, not theatrics, didn't blink, didn't warn again, didn't negotiate. She issued the order, marshals moved, and within minutes, attorneys who walked in wearing suits and briefcases walked out in custody. If you think this is normal, you haven't been paying attention. This redefines boundaries. This redraws lines. This changes how every attorney will approach a federal courtroom for decades. So what triggered it? Not emotion, not ego, not politics, at least not directly. What triggered it was cold, hard, documented contempt. 17 separate violations, weeks of warnings, multiple chances ignored, escalation after escalation, all meticulously recorded in an 18-page judicial order so surgically precise, so clinically detailed, that legal scholars are already calling it a masterclass in judicial restraint turned judicial reckoning. This wasn't a judge losing control. This was a judge laying a trap and watching the defense walk straight into it, step by step, violation by violation, until there was no choice left but to act. It started 3 weeks before the removal. Judge Caldwell had issued a pretrial order, clear, unambiguous, prohibiting either side from referencing certain prejudicial material that had already been excluded during motions. Simple rule, standard procedure. The defense referenced it anyway, 3 times, in their opening statement alone, not once, not twice, 3 times. Judge Caldwell called them to the bench, looked them in the eye, said verbatim, "Counsel, you are on notice. One more reference to excluded material and I will find you in contempt. Do you understand?" Lead defense attorney Marcus Renard nodded, said, "Understood, Your Honor." And then, the very next day, he did it again, during cross-examination, in front of the jury. When the judge pulled him aside to address it, he looked her dead in the eye and said, quote, "Your Honor, with respect, I believe your exclusion order was incorrectly decided and I intend to appeal. Until then, I'm going to present my client's defense as I see fit." That's not advocacy, that's mutiny. A federal prosecutor who was in the room told reporters Judge Caldwell's face went completely still. No anger, no shouting, just stillness, like she'd seen the end coming. She returned to the bench, instructed the jury to disregard the comment, then issued her first formal contempt warning on the record. That should have been the wake-up call. Instead, the defense hit snooze and kept hitting it. For 11 straight court days, they spoke over her rulings, addressed the jury after being told to stop, submitted motions that had already been denied 3 times, forcing the court to relitigate settled issues. On day 14, Renard refused to stop talking even after Judge Caldwell sustained a prosecution objection, kept going for 40 seconds, while she told him 6 separate times to sit down. The court reporter had to read back the transcript just to document how many times he ignored her. 6 times in 1 day. But here's where it all ended, the moment that turned a courtroom into a crime scene. During what should have been routine testimony, the defense introduced Exhibit 47D, an exhibit explicitly excluded, not just by pretrial order, excluded that very morning by Judge Caldwell herself. The prosecutor shot up. "Objection, Your Honor. This exhibit was excluded 3 hours ago." Renard didn't stop, didn't flinch. He held the document up toward the jury box and said, quote, "Ladies and gentlemen, the court doesn't want you to see this, but I believe you deserve the truth." That's not zealous advocacy. That's sabotage. That's turning the jury into co-conspirators. Witnesses say Judge Caldwell's gavel came down so hard the sound echoed through the gallery. Recess. Now. Clear my courtroom. Jury out. Gallery out. Press out. For 45 minutes, the room sat empty. Just the judge, her clerks, and the attorneys. When the doors reopened, 4 U.S. Marshals walked in, took positions behind the defense table. Renard reportedly smiled. He wasn't smiling 5 minutes later. Judge Caldwell read an 8-minute statement from the bench. Calm, methodical, devastating. She listed every violation, cited every warning, referenced every opportunity she gave them to comply. Then she said the words now echoing through every federal courthouse in America. Counsel, you have left this court no choice. You are held in criminal contempt. Marshals, remove the defense. And they did, handcuffed at their own table, in front of their client, in front of the world, processed through the courthouse holding facility, held for over 6 hours, released only after a magistrate set bail. This isn't theater, this is precedent. Now let's talk context, because this trial wasn't random. The defendant, Raymond Voss, former senior aide to a prominent political figure, facing federal charges including wire fraud, obstruction of justice conspiracy, politically charged from day one. Defense claimed prosecutorial overreach. Media coverage tilted, prosecution heavy. And the defense strategy seemed less about winning the case and more about making any conviction impossible to uphold on appeal. Enter Judge Caldwell, appointed by Bush, known for strict courtroom management. Defense immediately filed motions to recuse her. Denied. Filed appeals. Denied. Emergency stays. Denied. Legal analysts reviewing the filings say the defense shifted tactics at that point, stopped litigating the merits, started manufacturing chaos, creating what one former prosecutor called appealable error by design. Their theory, if they can't win, make the trial so tainted no appellate court will let a conviction stand. Judge Caldwell saw it, called it out in a pre-trial conference, on the record. I want to be absolutely clear with all parties. I will not be baited, I will not be provoked, and I will not allow this courtroom to become a circus. Counsel who violate my orders will face consequences. I hope that's understood. The defense responded by violating her first order within 72 hours. What followed? A 3-week escalation unlike anything veteran court observers had ever witnessed. Attorneys interrupted the judge, rolled their eyes visibly when she ruled against them, made statements to the media contradicting her gag order. By week 2, 7 formal warnings on the record. By week 3, 2 civil contempt findings, $45,000 in fines, paid without protest, then kept violating. That's when Judge Caldwell realized fines weren't working. That's when she made the decision that will define her legacy. Legal historians are already comparing this to the Chicago 7 trial, where defense attorney William Kunstler was cited for contempt over 20 times. But here's the difference. Kunstler's citations were widely seen as judicial overreach. He became a folk hero. Judge Hoffman? A cautionary tale. Judge Caldwell studied that history, did the opposite, gave warnings, documented everything, built an 18-page record that leaves zero room for spin. Then there's Joseph Fine in 1988, jailed for refusing to reveal client information. Principle, honor. Controversial, yes, but principled. Renard, not protecting secrets, not taking a moral stand, systematically violating orders to create chaos. The closest parallel might be Lynn Stewart in 2004, convicted of helping her terrorist client communicate with followers, sentenced to 10 years. But even that involved actions outside the courtroom. What makes this unprecedented? The contempt happened in real time, in open court, in front of a jury, direct, documented, defiant. Legal experts aren't divided, they're unified. Jonathan Turley, constitutional law professor at George Washington, called Judge Caldwell's actions textbook, said the 18-page order isn't just legally sound, it's strategically brilliant, created an unassailable record. Any appeal will have to confront 17 documented violations, repeated chances to comply. Ely Honig, former federal prosecutor, CNN analyst, emphasized the stakes. Criminal contempt isn't a slap on the wrist. These attorneys are facing prison time, real prison, not a fine, not a bar referral, actual incarceration. And given that record, I don't see how they avoid it. He added, handcuffing defense attorneys in front of a jury, that sends a message. You can push, but there's a line, and this judge found it. Even conservative voices aren't rushing to defend the defense. Andrew McCarthy, former federal prosecutor, National Review contributor, wrote, "Whatever you think of the underlying case, there's no defending what these attorneys did. A court order is a court order. You comply or you face consequences. That's not tyranny. That's the rule of law." Harvard's Lawrence Tribe put it bluntly, "This is judicial courage." Judge Caldwell knew she'd face criticism, knew this would become a political flashpoint, did it anyway, because the integrity of federal proceedings demanded it. So what happens now? First, the attorneys themselves. Marcus Renard and his two associates face criminal contempt charges. Maximum penalty, 6 months per violation. 17 violations. Theoretical exposure is massive, though actual sentences will likely be lower. More damaging? Professional consequences. Almost certain referral to state bar associations. Criminal contempt triggers automatic investigations. Suspension, disbarment. For Renert, a 30-year career could be over. Second, the trial. Judge Caldwell declared a mistrial immediately. Defendant Raymond Voss gets new counsel. Prosecutors plan to retry. But here's the twist. New attorneys will argue the contempt circus prejudiced their client, seek dismissal, claim jury pool is tainted. Judge Caldwell anticipated this. Her order specifically notes no evidence the defendant directed or encouraged the violations. She's protecting the prosecution's ability to retry, but appeals courts, unpredictable. Defense will file. Argue everything. Some arguments might stick. Third, the long-term implications. Every federal defense attorney in America is watching. Some see caution, others see template. Fear that Judge Caldwell's approach emboldens judges to crack down on aggressive but legitimate tactics. Counter-argument, she didn't punish aggression. She punished defiance, documented, repeated, deliberate. NYU's Stephen Gillers, legal ethicist, said this case will be taught in professional responsibility courses for decades. Masterclass in How Far is Too Far. American Bar Association signaled it'll issue formal guidance based on this. Whatever it says, one thing's certain, every federal defense attorney is rereading their ethics rules tonight. And then, the defense made it worse. Hours after release, Marcus Renard held a press conference. No contrition, no acknowledgement, just attack. Called it judicial tyranny. Said Judge Caldwell proved their claims of bias, called the contempt manufactured. The removal, political theater. When asked about the 17 documented violations, dismissed them. Zealous advocacy. I make no apologies. If that's a crime now, we've lost something fundamental. Problem? The violations weren't gray areas, weren't judgment calls. They were direct, explicit defiance. Introducing an exhibit excluded that morning and telling the jury, the court doesn't want you to see this. That's not advocacy. That's sabotage. Former federal judge Nancy Gertner, now at Harvard, pointed out the flaw. Worst thing you can do after contempt? Attack the judge. Judges talk. Bar associations take note. Appellate courts read press conferences. Every word he said today will be in the prosecution's sentencing memo. Added, if he'd acknowledged things got heated, expressed respect while preserving appeal arguments, defensible. This hurts him. Other defense attorneys, notably silent. Why? Public support could be seen as endorsing his tactics, and no one wants that on record. When your defense is attacking the judge instead of addressing the violations, you've already lost. But beyond the legal fallout, this is about something bigger, about whether courtrooms can function. Every trial depends on a compact. Attorneys advocate, judges rule. Everyone follows the rules. Break that, justice becomes impossible. What Renard and his team did wasn't zealous advocacy. It was an attempt to make the trial ungovernable, create so much chaos the case collapses, or the conviction can't survive appeal. If that works, if attorneys learn they can violate orders without consequence, every federal trial becomes vulnerable. Judge Caldwell understood the stakes. Knew removing defense counsel would be controversial, generate headlines, draw criticism, did it anyway. Because the alternative, surrender her courtroom to chaos. That's not tyranny. That's the rule of law, defended by someone willing to take the heat. Where things stand now, all three attorneys released on bail, hearing scheduled next month before a different judge, standard practice. Defendant Raymond Voss assigned new counsel, filed emergency motion seeking dismissal, claiming irreparable prejudice. Prosecutors opposed, calling it an attempt to benefit from former counsel's misconduct. Judge Caldwell hasn't ruled yet, but observers expect denial. Her documentation appears designed to preserve retrial. American Bar Association issued statement calling situation troubling, but notably didn't criticize Judge Caldwell. Bar associations in multiple states opened preliminary inquiries. Conservative media rallied behind Renard, framing removal as judicial bias. Liberal media backed Caldwell, emphasizing documented violations. What to watch? Contempt sentencing hearing could mean jail time. Bar disciplinary proceedings could end careers. Dismissal motion ruling will decide if Voss faces retrial and the appeals. Renard says he'll appeal everything: contempt finding, removal, sanctions. Those appeals will take months, years, but the image, defense attorneys handcuffed at their own table, that's not going anywhere. That moment already changed federal practice. The stakes, never clearer. A federal judge drew a line. Defense attorneys crossed it, and now cell doors closed, literally, on a legal strategy built on chaos. What happens next determines whether federal courtrooms remain governable or become arenas for whoever's willing to push furthest. Marcus Renard gambled no judge would hold him accountable. He was wrong, and every attorney watching, every judge, every prosecutor, every defendant just learned where the line is. This isn't just another contempt case. This is a reckoning. Hit subscribe, notification bell. Sentencing's coming, appeals are coming, and I'll be here for every moment.